So yesterday started a new term for the Supreme Court of the United States of America. And in this term, we already know that on November 3rd, the justices will begin oral arguments in the New York State Rifle and Pistol Association versus Bruen. And that is really, that's a question of has New York violated people's Second Amendment rights by denying them permits based off of their extra hoop you have to jump through stuff in New York. Well, there are 5 other Second Amendment cases that they began or were placed in front of them for consideration as of yesterday. Now, I waited specifically until it's about 2 o'clock here Eastern Standard Time today, and today is Tuesday, the 28th of 2021. Of September. I waited until the afternoon just to see if there were going to be any new orders that came out of the court today, and they didn't. So they are still considering these cases, and sometimes, as you've seen here before on the channel, sometimes they will kick those cases down the road or place them on hold based off of other cases they are considering. But I just want to give you all a rundown, a quick review, a synopsis of these 5 cases to put them on your radar because they should be. The first one is Russell v. New Jersey, and this is very similar to the New York State Rifle and Pistol Association case I just mentioned. And in this case, New Jersey said that the petitioner, the plaintiff, failed to show a justifiable need for a permit to carry firearms. Justifiable need. Literally, the Constitution of the United States is hanging right here, and it doesn't say it in there. I also have the Bill of Rights and the Declaration on this wall. Doesn't say it in there either, but New Jersey thinks that they can create this stuff, which is why it's made its way to the Supreme Court. Now, in some of these, I'm going to look over to my notes here because I want to get the specific questions before the court on these cases correct. And in the Russell v. New Jersey case, Russell is asking the Supreme Court whether or not the Second Amendment protects the right to carry arms outside of the home for self-defense, and whether the government may be denying law-abiding citizens their exercise of the right to carry a handgun outside of their homes by conditioning the exercise of the right on showings of need. Great question for the court, and I really don't see how New Jersey wins this. The second case you've heard a lot of. This is the longest case probably in the country. That was on the longest appeal ever. It's Young v. Hawaii. Now, the Young case is interesting. So, Mr. Young, who's a veteran, applied for open carry permit and applied for a concealed carry permit, was denied both. In Hawaii, they have never issued a concealed carry permit unless you're a armed security guard. They don't give them out. In the 20 years that they keep records, 0 have been issued. So, again, this issue, it was similar to New York. However, this case in the Young issue is not just for concealed, it's just for carrying a handgun for someone's safety in their own self-defense. According to the Ninth Circuit, if you remember this channel, you might remember this one. The Ninth Circuit said that neither the right to carry concealed or the right to carry openly is protected by the Second Amendment. And that is a major circuit in the United States, often overturned. It's called many things other than the Ninth Circuit. But that is the thought process in that group of jurisdictions, that group of courts. Crazy. So the Supreme Court, I think they're going to definitely, I see them taking this case up. We'll see. You can never really be sure what they're going to do, but that is case number 2. Now, the third case is the Association of New Jersey Rifle and Pistol Clubs versus Bruck. Now, this case, if you're in New Jersey, I'm sure that you're pulling your hair out on this one. Now, New Jersey has already had a magazine ban, and it was strengthened not too long ago. And in New Jersey, it's a 10-round limit. And before the upgraded restrictions, you couldn't manufacture or possess any magazine that had more than 10 rounds, or the ability to hold more than 10 rounds. But the new version of the law made those pre-ban magazines illegal as well. So if somebody had legally acquired them prior to the tyranny in New Jersey on the magazine ban taking place, they owned them lawfully, and they were called, pre-ban magazines. Those of us in the anti-gun states understand that. But this law, when it was tweaked, they made those illegal as well. Same law is being considered in Massachusetts. In case you live here and were wondering, Massachusetts has to be right up there with all these crazy laws, but that is the case before the court from New Jersey. And again, it's the Association of New Jersey Rifle and Pistol Clubs versus Bruck. And this case has two questions before the court. Number one is whether a blanket, retrospective, and confiscatory law prohibiting ordinary law-abiding citizens from possessing magazines in common use violates the Second Amendment. And two, sorry, my dog's barking. Number two, whether a law dispossessing citizens without compensation of property that was lawfully acquired and long possessed without incident violates the Takings Clause. You would think all day long, but especially if you're following these pandemic rulings, this isn't an open and closed case, but that is case number 3. The fourth one is Roundtree versus Wisconsin. In this case, there's a lot of people in the country who have been tied up into this loophole that was created by the government to be a backdoor gun control or backdoor gun ban. So the plaintiff in this case pled guilty to 2 counts of failing to pay child support over 20 years ago, and as a result, he's a felon. Because he's a felon in the government's eyes, he is a prohibited person. Some years later, he was caught with a revolver and some ammo and was charged as being a felon in possession of a firearm. And his lawyer is asking the Supreme Court if they would address one of the most vexing issues that has arisen since the District of Columbia v. Heller case, and that's whether and under what standards a non-violent felon seeking to keep a firearm in his home for self-defense may bring an as-applied challenge to the law that permanently strips all felons of their Second Amendment rights. We've seen a couple of cases that have gone before multiple levels of courts recently where someone's a non-violent felon, and there's been arguments that they should be able to enjoy their right to self-defense because the government doesn't give you these rights. But that one may or may not be taken up by the court, but that is case, I think that's 4. There's one more. I think I lost track during the way. But the 5th one is Weber v. Ohio. Now, in this case, Weber was arrested and charged with possessing a firearm while under the influence of alcohol. But the key thing to note in this case is that when the police arrived to Weber's home, the shotgun he was holding was unloaded. Now, of course, they appealed his conviction. It went to the Ohio Supreme Court for the state, and 4 judges upheld the conviction. It was a 4-3 decision. So now his attorney has appealed that to the United States Supreme Court to look at whether someone who's had a couple of drinks in their home is holding something that's unloaded. Does that necessarily mean they should lose their rights forever? So these are the 5 cases that were before the Supreme Court as of yesterday, and they were supposed to start reviewing these cases yesterday. I will keep my eyes open on whether they decide to issue a certiorari to these cases, meaning they'll take these cases up, or if I see a pattern of them booting them down the line each week. If you want to stay in the know, please subscribe to the channel. You can hit the button right down below. Make sure you toggle that notification bell to all notifications and share this with some like-minded folk. The more we have in the same realm of knowledge, the better off we're going to be. We can all be in the same boat, rowing in the same direction, and that makes us a much, much tougher group to pull the wool over our eyes. So thank you for your time. I appreciate you, each and every single one of you, much more than you know. And until we see each other again, be safe, stay vigilant, carry a weapon. I'll see you in the next one. Take care, everybody.